International law prohibits states to engage in war because its consequences are always heartbreaking and grave. Then, peaceful means, for example, negotiations, mediation, conciliation, inquiry, arbitration, judicial settlement, etc., should be the way to settle disputes. However, unfortunately, when countries are not able to solve their disputes peacefully, and while sometimes they don't even try, well, in those cases they often decide to resort to war, even if they give other names to it. Then war happens, even if nowadays, most of the time, it does not comply with international law. Actually, in the past international relations, the use of force, as for instance military operation, was legitimate. Very often, countries resorted to war or to the use of armed force in general because, well, war was perceived as a lawful tool, even without any legal justification to do so. It was only more recently, in the 1900s, the international community witnessed the international humanitarian law development. Like, you know, those very well-known Geneva and the Hague Conventions. Those are a set of rules aiming to protect civilians and people who are not directly involved in the armed conflict. Well, it all theoretically changed by the end of World War II in 1945, when the Charter of the United Nations came into force, radically changing the international legal regime concerning the use of force. It was this document that became what is nowadays the major legal instrument on trying to avoid war and the use of force in general. It wasn't a new idea because it all started previously in 1919 with the Covenant of the League of Nations, by which states agreed not to resort to war but to settle disputes peacefully, by arbitration or judicial settlement, for example, and all of that within the legal council. However, the Covenant failed to regulate violent self-defense proceedings other than war. A few years later, in 1928, the Kellogg-Briand Pact continued this process, saying that disputes should be settled in diplomatic ways. The problem was this pact did not indicate any measures other than the use of force itself.
The prohibition to resort to war is clearly stated in the Italian Constitution. Indeed, Article 11 affirms that Italy refuses war, both as a means for settling international disputes and as an instrument of aggression against other people's freedom. Furthermore, Italy agrees to the limitations of sovereignty that may be necessary to a world order, ensuring peace and justice among nations. In this regard, Italy aligns to international law, where the prohibition of the use of force is also one of the most prominent principles, expressly codified in Article 2, Paragraph 4 of the United Nations Charter. This rule declares that a United Nations member state cannot threaten or use force against the territorial integrity or political independence of another state. Although Article 2 does not refer to the word armed nor to similar expressions, the International Court of Justice has clarified that this provision only bans the use of military force, excluding from its scope different sources of coercion, such as economic sanctions or cyber attacks. In addition, this prohibition contained in Article 2 is an absolute one. States shall not use force except for individual or collective self-defense. On top of that, Article 51 of the Charter proclaims that this natural right races if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Therefore, according to the Charter, self-defense has a subsidiary and subsequent function, since states are under the procedural obligation to resort to the UN collective security system first, and the substantive right to react in self-defense only after an armed attack has occurred. The effectiveness of the UN security system, however, rests on the willingness and ability of the Security Council, and in particular of its permanent members, US, UK, France, China and Russia. The veto power of those members impeding the adoption of Council's decisions may render this security system highly defective and inconsistent. However, the prohibition of use of force remains uncontested. Even when states violate the rule, they justify themselves via legal arguments, actually reaffirming the existence of the rule and strengthening its normative significance.